For you guys that don't know me, my name is Ross Fox. I'm the president of the Federal Society here at Cornell. And today we're going to be hosting Michael Dorf and Hans von Spakovsky in conjunction with the Black Law Student Association on a debate about the Shelby County and the Voting Rights Act. So first I'm going to introduce Michael Dorf, and then I'll introduce Mr. von Spakovsky, and then we'll get started. So Michael Dorf is the Robert S. Stevens Professor of Law at Cornell Law School. Professor Dorf has co-authored books on the Constitution with Larry Tribe and Trevor Morrison. He writes a bi-weekly column for Justice Free Web magazine Verdict and posts several times per week for his blog Dorf on Law. Great website, by the way. Professor Dorf served as a law clerk for Judge Stephen Reinert of the United States Court of Appeals for the Ninth Circuit, and then for Justice Anthony Kennedy of the Supreme Court. Before joining Cornell, Professor Dorf served as Vice Dean at Columbia Law School. He's a graduate of Harvard College and Harvard Law School. Mr. Hans von Spakovsky is the manager of the Election Reform Initiative and a senior legal fellow at the Heritage Foundation. He's the co-author with John Fund of the book Who's Counting? How Fraudsters and Bureaucrats Put Your Vote at Risk. Before joining Heritage in 2008, von Spakovsky served 2 years as a member of the Federal Election Commission. Previously, Mr. von Spakovsky worked with the Justice Department as counsel to the Assistant Attorney General for Civil Rights. He also has taught as an adjunct professor at George Mason University School of Law. He served on the Board of Advisors of the Election Assistance Commission on the Fulton County Board of Registrars and Elections. He's a former vice chairman of the Fairfax County Electoral Board and a former member of the Virginia Advisory Board to the U.S. Commission on Civil Rights. He's a graduate of MIT and Vanderbilt Law School. So everyone take a moment, just welcome both of them for me. And as last stragglers come on in, I'm going to turn it over to Mr. von Spakovsky.
Well, I'd like to thank the Federal Society of the Black Student Association for inviting us both here to talk about this. Before we start talking about the Shelby County case, I did want to tell you something else, because you're all law students and you're always, I think, looking for summer positions. And so this is probably the most important information you can take out of here today. And that is that the Heritage Foundation, which is the largest conservative think tank in the country, we're located in Washington, we have an internship program. So if you're interested in that, go to the website and check it out. And we don't just hire interns in the summer. We have a summer, fall, winter, spring program. A lot of schools that have semester in Washington programs, students will work for us. And we have 3 big advantages over other Washington internships. The first thing is we actually pay you, which is not true of a lot of congressional internships. Second, you do real work. I can tell you that right now we've got 4 interns in the legal center, and they're doing real research, helping me write papers. A couple weeks ago, I had a commentary op-ed published in the Washington Times jointly with the intern that's working for me. And the third big thing for people interning in Washington is we also do something unusual. We actually provide housing for our interns, which is a good thing in a very expensive city that Washington is. If you read the editorial pages of the New York Times or the Washington Post, you would think that the Supreme Court threw out the Voting Rights Act. Well, I'm here to tell you that's absolutely not true, and that's not what happened. The Voting Rights Act is a powerful statute. Almost all of the provisions in it still remain in effect. And in fact, the most important provision of the Voting Rights Act, which was passed in 1965, is in full force and effect, and that's Section 2. Section 2 is the part of the Voting Rights Act that makes racial discrimination in voting illegal in the United States. It is a nationwide provision, and it's permanent. There are many other provisions in the law that are powerful tools against discrimination in voting when it occurs, everything from Section 11B, which prevents intimidation and threats of intimidation. The language minority provisions are still there. That's the provisions that require certain jurisdictions around the country to translate their ballots, and other provisions too. What was at stake in the Shelby County case was one provision of the Voting Rights Act, Section 5, and the accompanying coverage formula. And you need to know a little bit about the background of this to understand what the Supreme Court did and why, in my opinion, they did the right thing. The the Civil Rights Division, where I used to work, had been prosecuting voting cases in the South since the 1950s, under various other laws before the Voting Rights Act was passed in 1965. But they had a problem. In places like Mississippi and Georgia, where the worst discrimination was occurring, and this was, remember, systematic, official, widespread voting discrimination, they would go to court, they'd win a case, and then the local jurisdiction would find a way to evade the court decree and go get around it and go back to doing what they were doing. So Congress wanted to stop that, and the way they came up with stopping that was Section 5. Under Section 5, if you were a covered jurisdiction, you couldn't make any changes in your voting rules or voting laws without either getting the pre-approval of the Justice Department through an administrative submission or going to a 3-judge panel in Washington, D.C. You couldn't go to any other federal courts. You had to go to Washington and get a 3-judge panel to clear or say that there's no reason to object to your voting change. Now, they needed to figure out which states, which local jurisdictions should be covered under Section 5. So they came up in Section 4 with a coverage formula. Remember, the law was passed in 65. So the coverage formula they came up with was if you had a test or device in place in 65. So, you know, you had a literary test or something else that was intended to keep people from registering and voting, keep black Americans from registering and voting, and you had turnout, registration or turnout of less than 50% in the 1964 election, you were covered. Now, why did they use the registration and turnout number? Because the symptom of the terrible discrimination that was going on was low voter registration and low turnout by black voters. You could go to some place like Mississippi and you would find that the turnout rate of black voters was in the teens compared to the turnout of white voters in the 50th, 60th percentile. So that was the formula they used for coverage. Now, Congress did not make this a permanent provision like Section 2. This was supposed to be an emergency provision to resolve the worst problems, and it was only supposed to last 5 years. Now, in 1970, Congress renewed the law because they said the problems hadn't been solved yet, and they added the 1968 presidential election to the coverage formula. So if you had less than 50% turnout or registration in the 64 or 68 election, you were going to be covered. When they renewed the law again, they added the 1972 election. The law was been renewed 4 times, the last time in 2006. In 2006, Congress renewed it for another 25 years. But the coverage formula has never been updated since the 72 election. So in 2006, when Congress renewed the law, they were renewing it based on 40-year-old evidence and 40-year-old data. Now, you might wonder, why did they do that? Particularly because there were law professors like, in fact, Michael, we were talking about Nate Persley. Nate Persley, I think, wrote an article in which he warned Congress that they were going to throw the constitutionality of Section 5 into question if they didn't use current data when they updated the law. But, of course, there was a good reason why Congress didn't do that, because if they had used current data, if before the 2006 renewal, if they had used, for example, turnout from the 2000 election or the 2004 election, none of the 9 states that were covered would be covered. Why? Because as the dissenting judge in the District of Columbia Court pointed out, the registration and turnout rates of black voters in the covered jurisdictions in many places like Mississippi is on par with or higher than the registration and turnout of white voters. And in fact, the registration and turnout of black voters in the covered jurisdictions was consistently higher than the turnout in the rest of the country not covered under Section 5. So the Supreme Court threw out Section 4, the coverage formula, saying it was unconstitutional because it wasn't based on current conditions. And you've got to keep in mind this. In 1966, in a case called Katzenbach, the U.S. Supreme Court upheld Section 5. Now, the court recognized something that all of you, I'm sure, will also recognize because of the kind of system we live in, a federal system, in which our state governments are independent sovereigns. You know, this isn't France. The state governments, like the state of New York government, is not simply a subset of the federal government. And the Supreme Court in Katzenbach realized that Section 5 was an extraordinary intrusion into state sovereignty, because state governments had to go to the federal government to ask permission before they could act. But the court upheld its constitutionality because of also the terrible and widespread discrimination going on in the South. So it was an extraordinary intrusion into state sovereignty based on extraordinary conditions. Those extraordinary conditions didn't exist in 2006 any longer. In fact, the coverage formula, as I've said, if you based it on the coverage formula, none of those states would have been covered. The other thing that was pointed out by Judge Stephen Williams, the D.C. Court of Appeals, was that, in fact, not only did covered states have higher black registration and turnout than non-covered jurisdictions, but they have far more black elected officials than other states in the country that are not covered under Section 5. In fact, when it comes to black registration and turnout, the three worst states in the country in 2004, the last presidential election before they renewed it, were states not covered by Section 5: Massachusetts, Washington State, and Colorado. In terms of black elected officials in proportion to their black population, 8 of the top 10 states in the country were covered states. What were the worst states in the country in terms of the least number of black elected officials? The 4 worst states were Illinois, the home state of President Obama, Missouri, Delaware, the home state of Vice President Biden, and Michigan. Now, Section 5 was unprecedented in another way. This wasn't really discussed by the court, but it's something you need to understand. Those of you who've taken civil procedure, those of you who've taken criminal law, of course you know that in the United States, under our due process and under fundamental issues like that, the burden of proof is on the government when they're prosecuting you. And the burden of proof is on a plaintiff when they bring a civil case. Section 5 reversed the burden of proof. Jurisdictions that were covered, like Georgia, had to prove in court. They had the burden of proof. They had the burden of proving to the Justice Department that the acts that they did were not discriminatory in purpose or not discriminatory in effect. And that's something you need to understand about Section 5. You could have a completely benign purpose in passing a voting rule. Your purpose could be you think this will make all voters better, it'll put them make it easier to vote. But if it has a discriminatory effect, then it violated the law. The other problem you have to understand about Section 5 is that if you look at the entire history of it, since 1965, you'll find that the objection rate is extremely low. Let me see if I have the data here. Yeah, in 2005, there were 3,700 submissions made to the Justice Department under Section 5. The Justice Department only lodged 1 objection. In the last 10 years, out of 12,000 covered jurisdictions, there were only 37 objections. Shelby County is a county in Alabama. They went to court, and they weren't arguing that Section 5 was unconstitutional when it was passed. What they argued was that it was unconstitutional when it was renewed in 2006 because Section 4 was not updated. Shelby County has never had a single objection filed in the entire history of the Act. It's true that a few years ago there was an objection filed over an annexation and some other things that happened in one small town in the county. But of course, the county government has no control over what the city government was doing. The other thing you got to understand about Section 5 is that it has been abused by the Justice Department on many an occasion. Now, you don't have to take my opinion for this. If you got any doubts about it, I suggest you Google and look up a case called Miller v. Johnson. And look at both the Supreme Court opinion and look at the 3-judge panel decision. And what you'll find when you read that is that the courts were just shocked at the partisanship and bias of the lawyers at the Justice Department who were reviewing a redistricting plan out of Georgia under Section 5. In fact, the court in the Miller v. Johnson case basically said that the lawyers at the Justice Department were acting as if they were the in-house counsel for the ACLU. And he basically accused them of lying to the court over their activities in the case. You know, not only did the Justice Department lose that case, they ended up paying $600,000 to Georgia in attorney's fees and costs. There's another case like this out of Louisiana where a federal district court basically said that the division was, quote, using its power as a sword to implement forcibly its own redistricting policies. They ended up paying $1.1 million in attorney's fees and costs. And that's because Section 5 gives the Justice Department and a very small handful of lawyers there enormous power over redistricting in the Section 5 states. Some will argue that discrimination still occurs in the voting context. I mean, I don't contest that. But it's a rare instance compared to what was going on in 1965. And in the times when it does occur, there are plenty of remedies in the Voting Rights Act to do it. The Justice Department or individual plaintiffs can go to court under Section 2, and if they prove their case, they can get a remedy. Not only that, but there's this separate provision, I call it the custom Section 5 provision. It's called Section 3 of the Voting Rights Act. And what Section 3 allows you is, look, if you go to court, and right now Eric Holder's in court suing Texas over its voter ID law. And they have not only claimed that it's a violation of law under Section 2, but under Section 3, you can go to court, and if you can convince a judge that the jurisdiction is guilty of discrimination and that they are a recalcitrant jurisdiction, they're likely to repeat their behavior, you can ask the judge to basically place them into the equivalent of Section 5 coverage so that they can't make any changes in their voting laws without getting the okay of the Attorney General or the court for whatever period of time the judge thinks is appropriate. And so in the Texas case, Eric Holder is asking the court to put Texas into the equivalent of preclearance coverage for 10 years. Now, if he can prove his case in court, then he can get preclearance coverage. But compare Section 3, where you actually produce evidence that a particular jurisdiction is discriminatory, that they're likely to repeat it, and you get preclearance coverage with the blanket guilt imposed by Section 5 based on 40-year-old data. That doesn't make a lot of sense. And I don't think there's any need for Congress to redo the Voting Rights Act to bring Section 5 back by coming up with a new coverage formula, because Section 3 is there in case it's needed. And one of the things that I don't think anybody can come up with is any evidence of the chief thing that Section 5 was intended to stop. Remember, Section 5 was intended to stop jurisdictions from evading prior court decrees. There's been no evidence in decades that jurisdictions like Georgia or elsewhere evade court decrees rendered against them under the Voting Rights Act. There's no evidence of that, whatsoever. And is Virginia, which was covered under Section 5, so different today from the neighboring state of Pennsylvania? Is the state and local governments in Virginia so discriminatory that they need to be under federal jurisdiction, whereas Pennsylvania doesn't? I don't think anyone can rationally make that argument. And for those who say that, Section 5 needs to be kept in place because even though these jurisdictions are clean today and have been that way for a long time, they'll go right back to 1965 if Section 5 is gotten rid of. that's just not a reasonable assumption. Why? Because in 1965, there wasn't a single black elected official in any of these states because of the massive discrimination that was going on. That's not true today. As I said, the evidence shows there's actually more black elected officials in these Section 5 states than in the rest of the country. So the idea that they are going to tolerate or participate in this kind of discriminatory actions just doesn't make any sense. Plus, as I said, Section 2 is there in case discrimination occurs, and the Attorney General can go to court, and so can other organizations like the ACLU or the NAACP if they believe discrimination has occurred and they can get a remedy. So there's no reason for Section 5 and the coverage formula to be amended to bring it back. I'll close with one quick story, and I think this is important for you to understand. One of the other problems with Section 5, the way it's been currently administered, is that if you read the language of Section 5, it's intended to protect any group that is a racial minority in a particular jurisdiction. So that means, for example, in counties in Mississippi now, like Noxubee County, which is 80% African American. All the local offices are controlled by African American candidates. Actually, the racial minority in that county that should be protected by Section 5 are the white voters who are actually the racial minority there. But I can tell you the Justice Department doesn't administer the law that way. In fact, the former head of the Civil Rights Division is on record as saying that he doesn't believe in the race-neutral enforcement of the Voting Rights Act. And to show you how odd their views are, in 2009, there was a voting change in a small town called Kinston, North Carolina. You can Google this and look it up. Kinston is a town that is 65% of the registered voters are black. And they voted in a town referendum in the 2008 election, when they had very high turnout because Barack Obama was on the ballot, to change their city council and mayoral elections from partisan to nonpartisan elections. Now, black voters approved this. The voters of the town approved this 2-1 to go to nonpartisan elections. But Kinston was one of the towns, in one of the counties covered under Section 5. So they had to submit this referendum that black voters had approved to the Justice Department for preclearance. And you know what? The Holder Justice Department objected to the preclearance and said it was discriminatory. And they said it was discriminatory in their objection letter. Why? Because they said that black voters would not know who to vote for if there wasn't a party label next to the name, which I think is an unbelievably patronizing attitude by the lawyers in the Justice Department. They were basically telling black voters they didn't know what they were doing when they voted to approve this change. But that's just another example to you of how the authority of Section 5 has been abused by the Justice Department on too many occasions over the years. Thanks.
So I'd also like to begin by thanking the Federalist Society and the Black Law Students Association, especially thank Hans for making the trip. I realize it was a bit of a white knuckler there at the end, but we're glad you were able to come and join us on this lovely day. I unfortunately do not have an internship or externship program. I can't provide you housing, so I'm at that disadvantage, but I hope you'll listen to me anyway. Let me begin by saying that I actually agree with about, 75% of what Hans said. But I don't think that most or any of it really addresses the question that we came here to discuss. The question we came here to discuss was the Supreme Court correct in deciding in the Shelby County case that Section 4, the coverage formula of the Voting Rights Act, is unconstitutional? So most of what Hans told us was that there are flaws in the Voting Rights Act, either in the implementation by the Justice Department or in the design by Congress. And ordinarily in our legal system, if there are flaws in either the implementation or the design of a law, one takes one's case to the political branches. Either you complain to the Justice Department, you complain to Congress, you go testify, all the things that he does. What was at issue in the Shelby County case was whether those flaws were not just, policy problems, but actually rendered Section 4 of the Voting Rights Act, and essentially Section 5, because without the coverage formula, Section 5 is useless, right? Rendered these provisions of the Voting Rights Act unconstitutional. And if they're going to be unconstitutional, they've got to violate some provision of the Constitution. And I didn't hear what provision they violate. But I'll tell you what I think Chief Justice Roberts thought the Voting Rights Act violated, and why I think he's wrong. Okay? So the idea here, it's not that they violate any individual's rights, right? The plaintiffs in these cases are governments. They're state and local governments. In the particular case, Shelby County is a local government. Local government doesn't have rights under the Bill of Rights. Local government isn't even a state, but it's standing in the shoes of the state. So the idea here has to be that it violates principles of federalism, in particular the 10th Amendment. The idea would be that the federal government, in reenacting the coverage formula of the VRA without amending it, had exceeded the bounds of its enumerated power. Now you ask, well, is that true? Well, what's the enumerated power that Congress was exercising when it enacted the Voting Rights Act initially in 1965 and then updated it, renewed it various times after that? It was clearly attempting to exercise the power given to it by Section 2 of the 15th Amendment. Right? Section 1 of the 15th Amendment forbids states from discriminating on the basis of race with respect to elections. And Section 2 authorizes Congress to enforce that through appropriate legislation. And it's widely acknowledged that that formula in Section 2 invokes the same sort of power as Congress has under the Necessary and Proper Clause with respect to the powers enumerated in Article 1, Section 8 of the Constitution, with one possible exception to which I'll return at the very end of my remarks. So you ask, then, is the coverage formula necessary and proper to the enforcement of Section 1 of the Voting Rights Act? And remember, for a law to be necessary and proper to the carrying out of some enumerated power, it need not be a perfect law. It need not even be a very good law. It can even be a stupid law. But to quote Justice Scalia from his recent remarkable interview in the New York Magazine, right? A law can be stupid, but not unconstitutional. And I think what you've heard so far today are reasons why one might think that in some respects the Voting Rights Act, either in design or implementation, could be improved. The question is, does that mean that Congress exceeded the bounds of its enumerated powers? And there are basically three reasons given by the Chief Justice in the Shelby County case for why it appears to him and the majority in the case that that Congress exceeded its enumerated powers, none of which I think stands up to critical scrutiny. The first reason is this notion that Congress was doing something extraordinary when it enacted Section 5 of the Voting Rights Act, the pre-clearance requirement, or the requirement. It's actually not a pre-clearance requirement. Pre-clearance is an option, right? You can either, as a covered jurisdiction, get pre-clearance from the Justice Department, or you can go to the three-judge district court in the District of Columbia. Now, the question is this extraordinary? It's true that in South Carolina against Katzenbach, the court, while sustaining the law, does say, well, this is unusual, it's extraordinary, whatever. But the court doesn't apply heightened scrutiny because typically that's not the way the court operates when addressing the question whether Congress has exercised one of its enumerated powers appropriately. Right? So the idea that it's extraordinary has to come from some notion that The states are insulted when you tell them they have to get approval for their laws. Is that a principle of constitutional law? Is it a violation, at least prima facie, of the dignity or sovereignty of the states to tell the states that if they want to enforce their law, they need federal approval? Well, it may seem like it is, right? After all, Chief Justice Roberts, in his opinion, cites the fact that at the 1787 Constitutional Convention, there was a proposal that Congress be given a negative, the power to veto state laws, and that was rejected at the convention. And he suggests, so our system of government doesn't allow the federal government to negate state laws, right? It's a nice rhetorical move, but it's analytically false, right? In fact, the federal government does this all the time. Let me give you an example. The No Child Left Behind Act, which was passed during the second Bush administration, provides for all sorts of requirements on state governments that accept federal money, right? And the states are entitled they have to comply with those. But if they want to do something a little different, they have to get permission from the federal government. This is not unique, and it's not restricted to the spending power. Congress does this rather routinely. That is to say, it exercises the power that is sometimes called conditional preemption. It says, here's a federal law. States, you have to comply with it. If you don't want to comply with it, sometimes if they exercise unconditional preemption, too bad. States have to comply with federal law. States are sovereign in their domain, but if Congress has exercised one of its enumerated powers, that's it. Federal law is supreme, right? But in some circumstances, Congress then says to the states, you can get out of it if you get a waiver. There's an excellent, relatively recent law review article in the Columbia Law Review by Harvard law professors David Barron and Todd Rakoff called, with a sort of cutesy title, Big Waiver, which goes through this mechanism of federal lawmaking by which the federal government excuses states from what would otherwise be compliance with federal law. Let me suggest to you that that's all that's going on in Section 5 of the Voting Rights Act. Congress could have used its power under Section 2 of the 15th Amendment to preempt state laws that had the effect of that had a retrogressive effect on the basis of race with respect to voting. Instead, it exercised a lesser power. It said, if you're changing your voting rules, then you got to get preclearance. Why? What was Congress's reason for doing this? Because the experience that Hans talked about prior to 1965 showed that all sorts of nominally race-neutral rules governing voting had been used with the purpose and effect of disenfranchising racial minorities, especially African Americans, especially in the states of the former Confederacy. And so Congress said, but we're not going to just preempt it. We're not going to just write your voting rules because that would be too intrusive. Instead, we're going to allow you to have these changes, but just run them by us first. So what is being portrayed as an intrusion onto state sovereignty is actually an accommodation for state sovereignty. And the very evidence that was cited for you, the fact that the Justice Department approves the overwhelming majority of changes, shows that this is not a heavy-handed attempt by the federal government to squash state autonomy, but rather a scalpel, not a cudgel. So this idea that this is something extraordinary is simply false. There is a second argument that the Chief Justice makes in the Shelby County case. He says that the law offends the equal sovereignty of the states, that it is somehow an independent, freestanding objection to the law, that it applies differently in different states. Now, this is interesting, of course, because in the City of Bernie against Flores case from the 1997, the Supreme Court, in talking about the Voting Rights Act, praised that aspect of the law as showing that Congress wasn't overreaching. But never mind. Here it's being invoked as a new principle, the principle of equal sovereignty of the states. Is there such a principle? Well, there's a principle in the Constitution that no state may be denied its equal suffrage in the Senate without its consent. That's a constitutional provision. There are principles in Article 4 that provide that states have to respect one another's laws and enforce their acts, records, and judgments equally. Right? No state may deny to citizens of other states the privileges and immunities of the several states. There are all sorts of principles of equality among the states, but this isn't one of them. There is no constitutional rule that says that Congress, when it legislates, must make sure that it applies the same rules throughout the country. And for good reason. Right? Local, state, and regional circumstances vary. Let me just give you a trivial example. There are numerous provisions in the U.S. Code that refer to specific states in applying different allocation formulae. For things like travel reimbursement rates for senators, for things like how much funding for particular social programs, for things like where military bases are, all sorts of stuff that has very different impacts and they're explicitly treated differently. Nobody has heretofore thought that that was unconstitutional because different states are treated differently. And some are being treated better than others. That's just considered politics. So there's no general principle that that the court is invoking here. Judge Richard Posner wrote this in a critique of Shelby County shortly after the case was decided. The third possibility is that Section 4 is somehow problematic simply because Congress failed to update the coverage formula. Right? Some notion that Congress has a duty to seasonally update its laws. First of all, I would point out the absurdity of this idea in a country that is governed by a constitution that was adopted well over 200 years ago. But even if we focus just on statutes, there are numerous statutes on the books that have not been changed at all for much longer periods than Section 4 of the Voting Rights Act. Should Congress periodically update them? Thomas Jefferson thought all laws should expire after 20 years. It's not a bad theory, right? It's an objection to the so-called dead hand problem. Circumstances change. But there's another problem. It's called overcoming legislative inertia. Right? And so in general, we do not have a rule that Congress has to update our laws, even our laws that are out of date. If we think the laws are out of date, then we go to Congress and we say, try to update them, and we use the political process to do that. So again, it's quite possible that the coverage formula is out of date. That doesn't make it unconstitutional. But finally, I want to ask, do we really know whether the coverage formula is out of date? And here I just want to quote the nicest line in the case. Justice Ginsburg, in her dissent, says that it's not the reason why you haven't seen extensive racial discrimination with respect to voting in the covered jurisdictions is because of the success of the Voting Rights Act. She wrote, quote, "Throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet." Right? I thought it was a good line. Now, it's possible, right, that you throw away the umbrella and it turns out the sun is still shining. But I think the evidence we have in the period since Shelby County was decided indicates that while we're not in the thunderstorm of the Jim Crow era, it's still at least drizzling in the parts of the country, in some of the parts of the country covered under Section 4. So there's the Texas example. There's also the draconian law enacted by North Carolina relatively recently. And we have statements of legislators saying that they want to take advantage of the new freedom they have been given by the Supreme Court. I want to agree with Hans that technically they haven't been given any new freedom. The substantive obligations under Section 2 remain basically the same. But as a practical matter, these covered jurisdictions and the political officials in them understand that they have been given a new freedom because this procedural tool has been withdrawn. I have some other points, but I want to save a little time for questions, so let me stop there. Okay.
We're going to open it up for questions and answers, but because it's being recorded, I think I'm going to ask you guys to come down, just make a line in the middle. I'm going to hand you the mic so that whenever you ask the question, it'll actually be recorded. All right, first one.
So I want to use the example of Greg Abbott in Texas right now. He's, of course, running for governor against Wendy Davis. And almost instantly, as soon as Section 5 was repealed, he instituted new voting restriction laws, voter ID laws, which had previously been prevented. And they overwhelmingly disenfranchised students, minorities, and poor people. Whereas, for example, an expired gun license from another state is still considered valid ID. So when you look at this particular example, how can you say that this isn't a blatant attempt to disenfranchise Democratic voters?
Okay, well, you're making a number of mistakes. The first mistake you're making is Texas started looking at a voter ID law a number of years ago, and they passed it before the Shelby County decision. The same is true of the case in Georgia, South Carolina, which passed their voter ID laws. The claim that it disenfranchises individuals has been disproven by real data. Not surveys, not opinions, but real data. Now, why do I say that? Because the Georgia voter ID law, which is not any different than the one passed in North Carolina recently, was passed back in 2005. It was upheld by a federal court against a Voting Rights Act claim that was discriminatory in 2007. So the Georgia law went into effect in 2008. So we have data from the 2008 election, the 2010 election, and the 2012 election in Georgia. Georgia has a very large African-American population. It's about a third of the state. And just by coincidence, I happen to have the numbers here. In the 2008 election, now remember, the whole claim is that voter ID will keep racial minorities out of the poll and others out of the polls. In 2008, the first time the photo ID law was in effect in Georgia, Hispanic turnout went up 140% over 2004. Black turnout went up 42% over 2004. White turnout went up 8%. Now, when I throw out those numbers, people will say to me, oh, well, it's 2008. Black turnout went up all around the country. Barack Obama was on the ballot. That is absolutely right. But in fact, the Democratic turnout in Georgia increased by over 6 percentage points. It was the 5th largest increase of Democratic turnout of any state in the country, far ahead of many states without photo ID. The general turnout in Georgia in the November election, 2008, was almost 7 percentage points over the 2004 election. That was the second largest turnout in the country. The very same thing happened in Indiana. Remember, Indiana passed a photo ID law. It was upheld by the Supreme Court in 2007 and 2008. We have data from there too. In the 2008 election, when Indiana's photo ID law was in place for the first time, what the Supreme Court called the strictest photo ID law in the country, Democratic turnout went up there over 8 percentage points. It was the largest increase in Democratic turnout in the country. In the 2012 election, by the same thing happened in 2010, I won't bore you by giving the numbers, but in the 2012 election, again, you don't have to believe me, the Census Bureau just recently in May released its report on the November election. They do this after every federal election. And this is a report on the reported turnout by race in the federal election. In Georgia, blacks outvoted whites by 1 percentage point in the state with the strictest ID in the country. Same thing happened in Indiana. Blacks actually voted, I think, at a rate, I think almost 10 percentage points higher than white voters. This idea that it keeps people out of the polls is just not true. And sorry, it's a very long answer, but I will end with the thing on Texas by saying the evidence from other states shows students have not been disenfranchised. The reason in Texas that they were not going to accept a student ID as opposed to a gun license was very simple. In order to get a gun license in Texas, you have to be a United States citizen. to get a student ID in Texas, you not only don't have to be a U.S. citizen, but you can be here illegally in the country. And in fact, Texas provides in-state tuition to people who are here illegally. So a student ID would be a straight ticket into being able to vote illegally in elections.
So I just have one small thing. So Franita Tolson is a law professor who gave a paper in our colloquium a few weeks ago. And while she was here, I was talking with her about voter ID, and she's got an interesting view of she gave a paper about the Section 2 of the 14th Amendment, which is generally regarded as defunct, but she thinks isn't for interesting reasons. But she's an expert in voting rights law. And so she basically gave me an account that is largely in agreement with the data that Hans just gave you, but for a reason that he didn't mention, which is that the passage of voter ID laws is generally perceived, in my view, often with good reason, as an attempt to suppress African American voter turnout, and it often boomerangs, at least in the short run. So an increase in African American turnout in a particular place that has adopted a voter ID law is not inconsistent with the possibility that the voter ID law itself has a disparate impact, but it simply motivates people who who either have IDs already or now have the wherewithal to get them to go ahead and go to the polls. So that's her account of it after sort of some considerable looking. Now, there's then a question of whether that should count or not count as a disparate impact under the VRA. But I do think it's possible to have an increase in voter turnout of African American voters, and for a law to itself have a disparate impact with respect to ease of registration and so forth.
Thank you so much for coming today. Hans, I have a question more for you. When you were speaking, you stated that I think you gave an example where you said in North Carolina, you actually had more black voters, and you stated that in Congress today, you don't believe that we would have a return to 1965 simply because we have more black representatives. But I wondered what you would say in light of the fact that many districts are drawn taking into account the minority composition so that they preserve minority representatives only in that district, whereas as opposed to in other districts. Would your argument still be the same?
Well, in fact, that brings up an important point and something I didn't talk about, and that is actually, I think, one of the bad effects of Section 5 is it has created an almost apartheid-type redistricting system. Because under Section 5, jurisdictions are required to take race into account when they draw up districts. Now we've had gerrymandering for a long time in this country, ever since the first Congress. But most people I talk to think that the way redistricting ought to be done is it ought to be done in a way that, frankly, doesn't protect incumbents, but is done in a way that keeps towns, counties, communities together. That is not what happens today. And in fact, both political parties have just loved Section 5 for political reasons. Why? Because under Section 5, they were required to take race into account to create majority-minority districts. Majority-minority districts are districts where, for example, Hispanics or Asian Americans or blacks are a majority of the voters so that they can elect their candidate of choice. Well, the way, for example, the Democratic Party did that in Georgia, where I worked for a long time when they controlled the state government, was they packed black voters into suburban districts in Atlanta, for example, with 70, 80% black population. And that would create very safe Democratic districts where they'd have to really worry about challengers once they were elected. And the Republicans loved it. Why? Because by draining black voters out of surrounding districts, they created safe Republican districts. So there was this, what I think is just this terrible political bargain between the two of them to use this. And look, Section 2 remains. So if someone wants to go to court and argue, and MALDEF does this a lot, La Raza does this, that in order for Hispanic voters in a particular location to be able to elect the people that they want to have elected, that you need a majority-minority district, they can go to court and do it under Section 2. But one of the reasons, by the way, the Justice Department got in trouble in the Miller v. Johnson case was because they were insisting Georgia have majority-minority districts that were 85% black. And Georgia was saying, look, we don't need to do that. We don't need to drain these voters from surrounding districts. So that I think, is a real problem with Section 5, because it makes race a predominant factor in redistricting. And I don't think that's good for us as a country.
Yeah, let me just say a couple of things. So I agree with most of that. One is that the sort of high point of reading Section 5 as requiring majority-minority districts, I think, was in the Bush 1 administration, when you did have this sort of unholy alliance of Republicans and Democrats, and especially the Congressional Black Caucus, which was almost exclusively Democratic. But it was, you could see it as a kind of incumbency protection. I don't think that's a necessary interpretation of Section 5. And, to the extent that there is a problem there, the problem might be a case that we haven't discussed, because it's not a race case, a case called Veith against Jubileer, in which the Supreme Court basically rejects the notion of a constitutional challenge to political gerrymandering. Right? That is, a lot of what we see going on now, I would say that is, it's not that, I'm a Democrat, but I don't think that Republicans who are trying to dilute the black vote are doing it because they're racist. I think they're doing it because blacks vote for Democrats, right? And so it's an easily identifiable group. And so what one thing you might say is, well, we don't really have that much racist motivation in terms of racial discrimination with respect to voting. It's really all about politics. And, the Supreme Court, for understandable reasons about manageability, has tended to stay out of the area of political gerrymandering. But, if the court's going to stay out of there, one place where I think you can have sort of sensible, good government groups sort of apolitically get together is to try to have districting done on a professional, nonpartisan way. California has moved in that direction, I think, with generally positive results.
Thank you.
Great. Excuse me, I'm sorry. So, as you guys know, 3 counties in New York City are under Section 4.
Three of the 5 New York
boroughs.
Right. From
the Bronx, one of those boroughs that's covered. Majority, minority. We haven't had any problems with the DOJ since 1999. Haven't had anything rejected. But we've chosen not to opt out using the bailout option that I believe is under Section 3. So my question, I know you guys didn't really talk about that, but for these counties that have the option to bail out and to prove that they have not been discriminatory in some of their decisions, why have they not taken that option? And I feel like the argument is that this is an intrusion on states' rights, but if you have the right to opt out and you haven't been discriminatory and you can prove that, then you should be able to, you should just do that. So
that's actually a very good question. What he's talking about is Section 5 lays out a bailout provision. And what it basically says is, if you're a clean jurisdiction, and a clean jurisdiction is somebody who, for a 10-year period, hasn't had any voting rights judgments against them in court, has submitted all their voting changes and hasn't had an objection, they can go to court, again in Washington, D.C., and they can be granted bailout, so they get out from under the Section 5 coverage. The problem with the bailout provision was that back in 2009, there was another Supreme Court case called Northwest Austin Municipal Utility District. A little utility district in Texas sued, making the same kind of challenge Shelby County did. But the Supreme Court didn't get to the constitutional issue because they said, actually, this utility district, you can bail out. And the reason they hadn't been able to bail out before was because they said the Justice Department had been interpreting the bailout provision too strictly and had kept other people from bailing out. The other problem with that bailout provision, and this is a problem with the law, not just the way the Justice Department has interpreted it, It is that it's almost impossible for states or county governments to bail out. Why is that? Well, because in Alabama, for example, Alabama hasn't had an objection to anything that the state government has done in more than 20 years. But there have been a sprinkling of isolated objections to things that one or two towns have done in the state. That keeps them from bailing out. Why? Because if the state of Alabama wants to apply for bailout, the entire state has to have a clean record, despite the fact that the state legislature doesn't have any control over what some little town in some county does. The same thing with Shelby County, the case that actually went. Remember, Shelby County's never had an objection. But they were not eligible for bailout because there was an objection recently in one small town in the county over which the county government has absolutely no control. And Justice Thomas, in his dissent in the Texas case, he actually went to this very issue and said, the fact that there might be a way out of an unconstitutional statute does not make the statute constitutional.
Or, as I would put it, a statute that is flawed in some respects but not unconstitutional.
These are great questions. You guys obviously have very good professors here.
Hi. First, I have a couple questions, but the first is I was just wondering what your response would be to Professor Dorff's constitutional arguments, or what constitutional provision you would point to, and also what you would say to Ginsburg's argument in the dissent.
Well, I don't want to go on too long. I actually made some notes about that. I think it's inherent in our federal system. And it's also inherent in the way territories became states, that they were going to be treated equally among other states. And also, while the federal government has preemption in certain areas, immigration is one we can agree on, they don't have total preemption power in the election area. So the idea that the federal government can simply tell states what to do in this area under all conditions doesn't work. We know that because, for example, under the qualifications clause, the states are the ones who determine qualifications for voters voting for president and Congress. And that's why all of you can vote when you're 18. Well, you know, Congress passed a federal law changing the voting age from 21 to 18, and the Supreme Court said, well, while they might be able to do that for federal elections, they can't do that for state elections. They can't tell states how to run their elections. And so in an area where Congress has limited authority, if they are going to pass a statute in which they tell states what to do, they've got to have full authority to do that, and I don't think they do.
So let me just say, with respect to federal elections, right, Article 1, Section 4 gives states the initial power, but then Congress can completely change the rules regarding congressional elections. Now, what about state elections? There, the authority has to come from Section 2 of the 15th Amendment, and my argument would be, is that power, once it's exercised, is subject only to the limits of the necessary and proper clause. It seems to me the better argument, the argument that the Chief Justice Roberts hints at but doesn't actually make, is to say that, well, no, just as when Congress tries to enforce the 14th Amendment under Section 5 of the 14th Amendment, it has to adopt means that are congruent and proportionate to what the court would deem to be a Section 1 violation, so too with respect to the Section 2 of the 15th Amendment, it needs to enact laws that are only congruent and proportionate. That's a stricter test than the McCulloch test for necessary and proper. The court hasn't said that, though, and to say that it would have to overrule some of its prior decisions. And I think it would be unwise to say that because the whole reason for limiting Congress to congruent and proportionate means with respect to the 14th Amendment is that otherwise Congress could have a plenary power under Section 1 of the 14th Amendment because the language is so broad. As long as Congress is sticking to what it thinks are measures that are at least reasonably calculated to prevent race discrimination in voting, then in that limited area, I think under the McCulloch formula, its power is plenary.
The only thing I would, without starting a long debate, the one thing I have to say is this idea that Congress has complete and full authority over federal elections. That is simply not the case. If you look at the Elections Clause, you'll see that it says that Congress has authority over the time, place, and manner of elections. But the Qualifications Clause says that the states have authority over the qualifications of voters.
Well, it's the same as in the more numerous house of the state legislature.
Right. But the point of that is that, for example, you all know the National Voter Registration Act, right? Motor voter. Remember, when that was passed in '93, a number of states, including Illinois, went to court saying that it interfered with their authority under the Qualifications Clause, and the courts said they upheld the law, but only because they said that the NVRA affected time, place, and manner of elections. And I think it was the Seventh Circuit specifically said that if they thought the NVRA was interfering with a state's rights over the qualifications of voters, they would have found it unconstitutional. So Congress does not have 100% authority over federal elections.
Okay. My second question was, do you think that declaring the provision unconstitutional is going to have a disparate impact on African American voters?
No.
Do you have any other thoughts about that? I mean, I feel like we've kind of had a window into what it will be like since there have been all these cases about preclearance. We've had a window into what states will do with this power when they're, or not power, but without having to preclear. And it's pretty clear that that's going to have a disparate impact on minority voters.
You're laboring under the assumption that passing a voter ID law is a discriminatory act and has a discriminatory effect. The majority of courts that have looked at that law have held completely the opposite, including, very importantly, like I said, federal courts in Georgia who specifically looked at this issue had said it is not discriminatory. And in fact, the effect of the laws, this is a point actually made in a piece in National Review about a week or so ago. The lawsuits that upheld, for example, Georgia's voter ID case, the lawsuit that upheld Indiana's voter ID case, those were facial challenges. As you all know, that means you're challenging the law, saying that on its face it's unconstitutional. Both of those decisions meant that if in the past 5 or 7 years that the law has been in place, if the ACLU or anyone else could actually find somebody who was unable to vote because of those laws, they could have filed an as-applied challenge. Since the Georgia law went into effect in 2008, there's not been a single as-applied challenge filed. And the same thing is true in Indiana. They haven't been filed because they've got no proof that these laws are discriminatory.
So these are the states where they have passed preclearance, but in states that they haven't, it's been shown that they
Indiana has no preclearance requirement.
In South Carolina, for example, it was shown that the voter ID law would disenfranchise 60,000 registered black people, and
a 3-judge panel disagrees with you.
I don't think
South Carolina went to court and they challenged the objection that was made by the Holder Justice Department. You can look and you'll find an opinion from the District of Columbia Court in, I think, October of last year, in which the 3-judge panel overruled the Holder Justice Department, held that the law was perfectly okay under Section 5, and the South Carolina law went into effect in local elections in 2013.
Right. Can I jump in here? So let me make just 2 small points. One is that even the Justice Department distinguishes among voter ID laws. Right? There are some that they say will and some that they say will not have a substantial racially disparate impact. I think it is clear to my satisfaction that at least part of the motivation for the enactment of some voter ID laws is political, a calculation that it will lead to fewer people being qualified to vote who tend to vote Democratic, because these tend to be in places that are Republican. I think that's undeniable.
I would deny.
I understand. Now part of the reason I think that is because Hans and I have a fundamental disagreement over the need for voter ID laws in the first place. He thinks that in-person voter impersonation is a serious problem. People who I regard as generally credible have disagreed and challenged him to provide evidence, and I don't believe he's provided satisfactory evidence. So you can look at Rick Hasen's piece on Talking Points memo, which I linked to on my blog now. But he may be right. Maybe they're wrong. Right? I'm not an expert. But I just think looking at the pattern of the places that enact them, it's hard to resist the conclusion that they are enacted in the hope that these will result in fewer people voting for Democrats than for Republicans. I think the interesting thing from what Professor Tolson shows is that hope, I think, turns out to be false. And so to me, that's a really interesting question, right? If you have a law that is enacted in part because of the hope that it will have a disparate impact, but doesn't in fact have that disparate impact, is that law invalid under a law that forbids purpose or effect of racial disenfranchisement? I don't really answer that question, but I think it's an interesting question.
Well, what we need to do is you need to invite me back. We'll have an hour-long debate about voter ID.
Okay, thanks.
Okay, I guess I'm last. You've spoken very eloquently about the possible lack of wisdom of such laws. However, if I could harp for one more moment on the actual constitutionality of it, could you discuss your critique of Professor Dorff's assertion that Section 2 of the 15th Amendment gives Congress the power to pass such a law, and could you posit a theory constitutionally of why that is not the case and why the law is unconstitutional?
You get 30 seconds to do it.
Look, there's a very good discussion in the oral arguments and I think in the decision over the Obamacare case where, look, I went to all 3 days of the Obamacare arguments. And the reason I mention that is that part of the government's argument in that case was that the necessary and proper clause means that the government can do anything it wants, basically. That in essence, because of the necessary and proper clause, it can engage in any kind of legislating it wants. But as the court, I think, pointed out, the necessary and proper clause is there to uphold the enumerated powers of Congress. And Congress's power is at its lowest ebb when it is imposing requirements on state governments. If it's going to impose a requirement on a state government like Section 5, which I think is unprecedented, of getting pre-approval for things the state government does, it's got to have very good evidence of why it can do that. And I don't think it's got the evidence to do that, particularly because something I haven't mentioned is, the 15th Amendment, I think, prevents intentional discrimination. That's not Section 5 at all.
So let me just respond to that one last point. By its terms, the 15th Amendment doesn't say whether it imposes an intentional discrimination or a disparate impact test, but it's true that the courts have construed it to forbid intentional discrimination. And so the question is whether Congress, in the exercise of its power, can say that we're going to adopt a prophylactic measure because we can't prove intent in lots of cases. And so we're going to take disparate impact as the signal for intent. I think that Congress does have that power because of the nature of Reconstruction, which fundamentally changed the relationship of the states to the federal government with respect to this area. But some people disagree, and some of those people are on the Supreme Court.
Thank you very much for your answers, and not to preempt what I'm sure is going to be a wonderful goodbye, but thank you very much for coming.
Thanks so much for coming.
Oh, sure. Well,